Court ruled a ban on abortions after 20 weeks is unconstitutional. Advocates on both sides are taking a closer look at South Carolina's law.
Well, the Palmetto State has a law that makes most abortions after 20 weeks illegal. 7 News anchor DIANE Lee looked into how this new ruling could impact plans in South Carolina by some lawmakers for more restrictions on abortion. DIANE.
Yeah, well, Gordon and Amy, the abortion ban in South Carolina went into effect in May of 2016, and so far it has not been challenged. But now that a federal judge has struck down the similar ban in North Carolina, it's more likely that will change. The federal court's decision to strike down North Carolina's 20-week abortion ban as unconstitutional comes at a crucial time for advocates on both sides in South Carolina.
The court just struck down 20-week ban, and now South Carolina is trying to push a 6-week ban here in our state. So our lawmakers should understand that that is very unconstitutional.
Ashley Lido with the Women's Rights and Empowerment Network says even if the 20-week ban in the Palmetto State is not challenged, she believes it's far less likely South Carolina lawmakers will succeed in passing what's being called the heartbeat bill. That legislation in a House subcommittee right now would ban abortions after a heartbeat can be heard as early as 6 weeks. But if you ask pro-life advocates like ALEXIA NEWMAN, the executive director of Carolina Pregnancy Center, it's the pro-choice advocates who are trying to chip away at the legal protection of a child.
For me, it just makes me more resolute. It makes me more determined that no matter what North Carolina does, or any other state for that matter, we're going to keep doing what we're doing. We're going to keep fighting.
Just this year, 11 states have introduced fetal heartbeat legislation, including Texas and Florida. And last week, Mississippi's governor signed its heartbeat bill into law. But those stricter bans face mounting opposition. Some pro-life advocates say the end goal is to trigger a legal challenge at the Supreme Court level to overturn Roe v. Wade. So, Gordon, the judge gave North Carolina lawmakers 60 days to either write a new abortion law or appeal his ruling, and at this point that's still undecided.
So neither of us are lawyers.
Right.
But if a federal judge says 20 weeks is unconstitutional in North Carolina, why did that not automatically become unconstitutional in South Carolina?
Very good question. Well, all these states have different laws, and they have slightly different aspects to the law. So because of that, it's not a blanket policy. And again, this can be appealed. I think this is going to be something that's going to take a long road to iron out.
The court battles over abortion have been going on since '73, and they will continue. Won't they? All right.